Thank you very much. So ours is a two-part presentation, and Ed gave the first part last week. So I'm going to continue with the remainder of the presentation and try to leave a decent amount of time at the end for a few questions. So just bear with me one moment as I share the screen and bring up the presentation. Okay, so we're going to start with what we're calling operational issues. So this relates to the first thing that I want to talk about are vendor contracts. And this could, it doesn't necessarily have to be vendors, but it's sort of any contract that and what we're thinking about here is any contract that the nonprofit is paying someone for service. And unfortunately, given COVID issues, complications, there's been a need for folks to renegotiate or terminate or somehow modify their contracts. So this is actually something, especially in the last year, that I've done quite a bit, especially as related to event contracts, larger event contracts with hotels and event service providers for nonprofits that were planning to put on events in 2020 in person and then could not do it, as a lot of us experienced the same thing, unfortunately. So the first thing to say is a word of encouragement, I suppose, is we were, in my case, we were able to not pay any substantial penalties in canceling or modifying the contracts. And really the first step is just to bring it up with the vendor and to ask. And don't be afraid to mention that you're a charity or whatever type of nonprofit you are, that it has always seemed like it's resonated in these situations for me. So the first thing to think about is, well, can we just terminate it and not be liable for any damages or money or anything? And you would look at the termination clause and think about what constitutes cause if there is a for-cause termination. Can you terminate for convenience? And in most of the contracts that I've dealt with, unfortunately, you can't terminate for convenience by the terms of the contract. Think about what the notice period is and how you give notice. Usually email sufficient. Who do you email? Just sort of practical things like that. And then, unfortunately, if there's any acceleration or penalties, you want to think about those. Force majeure and impossibility became sort of buzzwords around this time last year. There's a lot of talk about those in March and April, especially related to event contracts. So a force majeure clause is an act of God, and the concept is that if there are certain acts of God that make the contract impossible, this is sort of a traditional force majeure concept that there's no liability on either side. So what I would say is I never had to go so far as to officially invoke a force majeure clause over COVID, but what it did cause to happen is us to discuss these with our clients and folks on the other side of the contract and try to demonstrate how it could be invoked in certain situations. And if it sort of went all the way and there was a lawsuit, it's not required that one of the causes in there that would allow invocation of of force majeure is a pandemic or epidemic. If it would say something like acts of God limited, but including but not limited to, and then the stuff that they would have in that list, would be indicative of something like a pandemic, or not even, because it's still sort of an act of God, then that might be enough. The other thing that thinking about force majeure in older contracts made me do is think about it in new contracts. And a few things for you to think about maybe adding would be commercial impracticability in addition to impossibility. You could also add something like, and I really like this, where you're the one paying and try to get out of it. If 30% of our folks can't get to the event because of transportation curtailment related to X, Y, and Z causes, then that's going to constitute force majeure under this agreement. So the situation that you will more often, I think, not find yourself in when you're trying to get out of one of these contracts is pointing to a good force majeure section that you negotiated in advance and saying, hey, look, we can get out of this, right? But we like your hotel, we like your event. What we'd like to do is have some sort of option for next year or in 2 years or something like that. That's how, as a matter of course, a lot of these things got resolved for my clients. And the last thing that I want to say on force majeure is, if you're asked to negotiate, for example, a hotel contract, I've been doing several of those for my nonprofit clients, don't accept as gospel or as an unchanged, as something that cannot be changed, the language that the hotel gives you. The hotels will negotiate on their forms much more than you think. And the places where you're going to really care to negotiate include the force majeure, liquidated damages, and excuse me. Well, those are really the main things. Liquidated damages, sort of reducing your liquidated damages and force majeure. And then in the last, if you can't get out of anything, you're thinking about what happens when someone breaches and what the liability is. But what I want you to sort of take away from this slide is try and ask first, and in my case at least, we've been pretty lucky and fortunate and not having to pay termination damages or anything like that. So I'm not going to touch too much on employment stuff, but just sort of give some pointers on issue spotting. Unfortunately, because of COVID, folks have had to be laid off, terminated in the last year from nonprofits. And the first thing to think about is whether you're the person who is going to no longer be with you is an employee or a contractor. And regardless of whether you call them a contractor, the whether or not there'll be one is a matter of, and for tax purposes, is a matter of whether the IRS sort of says they are or not. And there's a 20-factor test. What it gets down to really is how much control / lack of independence does the person have. So where you organization are saying, I want you to plan X event on Y date and do whatever you need to do to do that, and maybe you're doing 2 of those a year. You're not spending anywhere near 40 hours a week or anything like that. In the absence of anything else, that obviously looks like a contractor, not employee. And it's more expensive, obviously, generally to have an employee as opposed to a contractor. So on a high level, what are you thinking about when you're terminating a employer contractor? Well, you're looking at whatever underlying document, if there is one, deals with the relationship. So is there a contract or is that will? And what does the contract say in terms of termination? Um, you know, another thing you might think about is whether the employee is part of a protected class, as a matter of federal law, in some cases state law. And then if they are leaving, especially in the case of an employee, consider providing the opportunity to resign, paired with a separation agreement, which may include some compensation amount, a month's salary or something like that. And one thing to just generally think about here is that, nonprofits often aren't used to hiring outside counsel or outside professional service, especially if they're smaller and just sort of getting going. They're not used to hiring those sort of folks. And it can be expensive, or it can feel expensive. The one sort of place where we see more litigation than any other, I think, as an employer is concerned, and nonprofits are no exception, is when there's termination of a relationship with an employee. So you're just going to see a lot of litigation there where you don't see other places. So if there is a time to think about spending money, that often is it. That's often a really good use of resources. And maybe you do it the first time you terminate somebody, and then you sort of have an idea of where things are going forward. So it can be sort of a value add going forward too. So the next sort of thing that we're going to talk about is disaster relief payments. So these are payments related to something experienced related to a disaster. They can be cash payments or provision of other sort of help or assets. But so COVID-19 was designated a quote unquote qualified disaster by the federal government. And that has fairly wide ranging implications for the way that tax exempt organizations and employers in general, regardless of whether they're tax exempt, can think about giving money to people, in particular their employees. What I want to focus on sort of is a subset of that is how a 501c3 organization, specifically a public charity, can think about getting cash to certain people in a qualified disaster situation, such that it's a valid charitable activity and not taxable to the recipient. This may seem like just a very basic charitable thing to do, but the IRS has put in quite a few restrictions and safeguards, maybe it was the way that they would put it, as to how this happens. This came up quite a bit after 9/11. About how aid is to be given to individuals, and since then there's been some clarification as to how it happens, but as an overall sort of concept, disaster relief money or money provided to folks from a charity after a tragedy in their life can be called sort of a somewhat unsettled part of tax law, and should be approached with a good degree of care. So what I'm envisioning here is a situation in which an existing charity sees the COVID disaster or another similar sort of widespread problem that becomes a qualified disaster under federal law, and thinks about starting a program where they want to give people cash. So the first thing to think about is really governance and compatibility with the mission. And Ed talked about this in our first session. So your articles of incorporation and bylaws and maybe a board adopted mission statement will all or some of them will touch on the bounds of what the organization has decided for itself that it's going to do. So the question is whether, or an initial question is whether this program that you're envisioning fits within that vision. And if it doesn't, the board, and even if it does really, but if it doesn't, the board should, one of the first things the board should do is say, hey, should we do this? Do we have the capability to do this? How's it going to work? And then if there needs to be any change to the governance documents, usually there doesn't. But if there does, those things should be done at the outset. So the next thing to think about, so we've decided our public charity has decided it's going to start up this program, and let's say it's allocated a few $100,000 to the program in money that it had, in the unrestricted funds that it had. So the first thing is you're going to want this direct payment to individual program to benefit a charitable class. So a charitable class is a group that can receive assistance in a situation like this. It's a group of people that's larger and definite enough such that said benefits derived aid the community as a whole, and not a pre-selected group of people or too small of a group of people. So the folks that live in a particular state could, as an initial sort of threshold, be a charitable class. The folks that live in a particular house, that's too small. That's not going to be a charitable class. There's ambiguities here as to who can be and who can't be a charitable class, but think large and indefinite, and generally like folks in a city or something like that's large enough. So there's a charitable class, and then what you're going to do is establish a needs-based test and maintain proper documentation for these cash payments. So what that means initially is you're going to keep a record of the description of the assistance, how the recipients are selected, what are your criteria for distribution. You're going to keep a record of who the committee or the board approving these payments are, who those people are. So continuing, when you're establishing the program, as we discussed, it can't be for a pre-selected group of people. And that sort of relates back to charitable class. And I think that's fairly understandable that you can't say this is for a particular family or something like that. And an important thing, changing our hypothetical a little bit, let's say that you start your program and you're raising funds at the same time to help folks. The solicitation materials themselves should be very clear that the ultimate discretion as to how the money is spent rests with the 501c3 public charity organization. The donors themselves aren't directing it to a certain group of people, for example. And you should have a process whereby the distributees are applying, and that again goes back to your needs-based assessment. They need to demonstrate the need for this. So what I've talked about thus far is aid to individuals or families. What I want to talk about now, which is a little bit more unsettled perhaps, or difficult or complex, is aid to businesses. So businesses can't be part of a charitable class. So a group of businesses themselves are not a charitable class, but the aid to a business can be means to a charitable end. So for example, this is sort of the most direct one, combating community deterioration. If there's a particular area of a city that's blighted and doesn't have proper services for its citizens, like if there's a for-profit health clinic or something like that, that's about to leave, there are or about to go bankrupt, there are ways to fund that business such that it's a valid charitable activity. So it's I would say that it's harder to do this, and it's just more difficult to do it for most public charities compared to aiding individuals. So what you're going to want to do, and again, this is sort of, it's somewhat similar in that, this could be part of an application process, or should be part of an application process, I should say. You would need to establish that the business lacks adequate resources from its own assets. It can't get conventional financing, and it's not covered by insurance for for the amounts that you're providing. And it's important to determine that without the intervention, that the business, is going to cease to exist or leave the area. In situations like that, it's permissible to have the charity give a grant to the business. But again, what I'm giving you here is a fairly high level and broad overview. You're going to want to sort of get more into the weeds of the IRS guidance and tax law on all this stuff if your clients are going to be doing something like this, or if a nonprofit you're involved with is thinking about this. So the next few slides are providing a lot of detail, and I don't want to go through all of this because I don't think all of it is applicable to most of the folks here. But when the IRS and when we talk about these disaster relief payments, what we're talking about is broader than just if a public charity is giving funding or assets to people or businesses. It's sometimes the case that an employer, a for-profit or nonprofit employer, is giving funds or wants to give funds directly to employees related to a disaster or some other hardship. And there are several ways to do this, tax efficient ways to do this. The first is the direct employer assistance under 139. That came about in the last, I think, or became common at least in the last 20 years or so. There are employer-sponsored private foundations. So I apologize if for some of you this is repetitive or too basic, but there are several different types of 501c3 organizations. A public charity is a 501c3 organization that has at least somewhat broad support, financial support from a generally wide swath of the public. And because of that, the restrictions on the way that it uses that money from the IRS are somewhat less, under the theory that there's a larger group of people, as opposed to a private foundation, which we'll talk about in a second, that are thinking about and looking at this public charity. A private foundation is it's still a charity, but it's supported by a smaller group of folks, like a family or an individual donor or a couple or something like that. In the late 60s, there was concern, and rightfully so, that these organizations that were run by fewer groups of people didn't have enough oversight and were doing things that were untoward, like providing a grant to a college that was essentially like a tuition payment for their kid. That I don't know that ever happened, but that's the type of stuff that the IRS was worried about. So they promulgated a bunch of regulations and laws that essentially put tighter restrictions on the way that a private foundation spends its money. So the bottom line takeaway from this is that you may want to take is a public charity is more flexible in the way that it can spend its money versus a private foundation. There's more restrictions on a private foundation. So a company can create a private foundation, and it can give tax assistance to, it can give direct financial assistance to its employees under certain parameters, and some of this is laid out right here. There's also employer-advised disaster relief funds, where the employers can cause their employees to get financial assistance. There are employee sponsored public charities, where, because of the financial sort of makeup of the organization, the income, the organization is able to qualify as a public charity, and those organizations can provide financial benefits to the employees. There's non-advised disaster relief funds that also can be established at an existing public charity, and these can provide support to the employees. The difference here is that there's a cost involved, there's a payment involved to the public charity, both to establish the program and then on a per application basis. So your employees are applying for this funding, and each of those applications will generally incur a fee. So, because the employer is divorcing itself of nearly all control here, the folks that are going to select who gets the money are within the public charity. That's something to consider for the employer, the lack of control, and the contributions that are deductible and the relief payments are tax-free to the employees. So I hope you all can see this. This is a chart that Ed helped put together that sort of goes through the limitations and the tax advantages of these different programs. So again, this, the reason I bring this up is because there's been a lot of talk about it in the last year in particular, about how employers can do this. And I just thought it could be of interest to the folks attending. The next thing to talk about would be restructuring, merger, and dissolution. I think that the next presentation relates to bankruptcy, so I'm not going to cover that at all in this. So let me just talk generally about this. COVID has produced in our practice at least more discussion and thought about things like merger and dissolution for various nonprofits. We have thankfully not seen a rash, in our practice at least, of dissolutions, and I've been looking for data on this, and nationally, I don't know that it's been as bad as folks thought it would be, but anytime there's a change to the way that we all are living our lives, it's wise for a charity to not necessarily think about merging, but to evaluate, are we still is the way that we're doing business still helpful to people? Are we still fulfilling our mission? Do we need to change the way that we're doing things from an operational or legal perspective, in order to better fulfill our mission, given that we're in the situation that we're in? So I'm looking at this discussion more holistically, rather than, oh God, we've run out of money, now we got to merge or dissolve. And the first sort of topic leads to this. So and this is, I suppose, perhaps a little bit more operational than legal in scope, but given that a lot of nonprofits were human to human facing. Think about, food banks where there's a lot of people working there and there's a lot of people bringing in food and things like that. Um, they there has been the need to think about, well, needs on this sort of in this sort of area are higher um, than this other area. What do we do to address that? So what that could involve is, just a simple allocation of resources, moving around business units, and from a governance perspective, you know, generally when we sort of lay out basic compliance steps for a nonprofit that's providing services, or really any nonprofit, the nonprofit's going to pass a budget every year and then monitor compliance with that budget. So, do you need to amend your budget? That's something that the board is usually going to be involved with, and certainly at least aware of. So that might, I know this is not exactly internal restructuring, but I did just want to mention stuff like that as related to governance, which we talked about in the previous session. Another thing that I've talked a little bit about with folks this year, and is a good thing to think about every few years, is how do we, the nonprofit, get money out? And I'm specifically thinking about grant-making organizations and the burden on the board in some organizations to review grants and approve grants as they come in. So even though you're approving a budget, as the year goes on, you're budgeting $100,000, let's say, for grants, and you're getting those requests in through the year. So the way that a lot of organizations do this is they'll have, the board will approve particularly large grants, and then a grants committee or something like that that the board creates will have other grants. So let's think about that for a minute. So a typical way that will work is the board will say grants under $20,000 will be reviewed 4 times a year by the grants committee, and the board will set a charter for the grants committee saying who's on it, how often do you meet, and what do you review in terms of providing folks money. So because the needs in the last year were so great, what we saw, and this is not necessarily just related to COVID, it can be related to any number of things, but what we saw was a need to get money out faster, and a way to do that is thinking about a grants committee that's smaller than perhaps your large board, and that can be more flexible and meets more frequently, perhaps. And then other things to think about in terms of internal restructuring are what your officers do, who they are, how many of them there are, should there be more, and should that be reflected in a change to your bylaws where you're defining the roles of officers. And then authority flows. Again, this is sort of more of an operational type of issue, but are the authority flows proper among officers and among committees and things like that. So sort of a more intensive thing in the area of merging and restructuring and dissolution would be a strategic combinations, this particular strategic combination that I want to talk about now is a quasi merger. And the way that I'm sort of thinking about this is, I'll give you an example because I think that might help. So we have an international aid organization that gives money, that's quite large, gives money throughout the world through funds that it gets from USAID, let's say, or the United Nations. And there's a similar organization that's a bit smaller that's particularly effective in certain regions and just has great sort of grants management capacity and technology and things like that. So what a quasi merger could be is the larger organization pays the smaller organization to do some of its grants management work for it. And in this situation, the efficiency and the overall goal of something like this is just enhance efficiency. So in this situation, the things that you need to consider as you're negotiating this is, if you have a conflict of interest policy, you would need to follow that with the concern that there's folks on both sides of the transaction. You would need to make sure that the rate that you're paying is fair, that there's no sort of excess private benefit. Generally, what we're talking about in a situation like this is two 501c3 organizations, and one is essentially providing service to another. It could be the case that they are each providing services to each other and paying each other, a sort of cost sharing arrangement. The bottom line, the reason that I mentioned this is that it's a step short of a merger or dissolution that could increase efficiencies. So this is something to think about. There are tax considerations when a nonprofit is providing services and being paid for those services, and when it's generally related to the mission of the organization, that's not going to be taxable. But in some cases, it is going to be taxable. This is a big topic, and there's sort of a lot to it. But I did just want to mention this as something that during a crisis that could be helpful to increase efficiencies and causing you not to have to merge or dissolve. So the next thing we'll talk about is a merger. So a merger is, it's similar to the for-profit context, except there's not stock involved with two or more entities. So one entity is the big fish and it swallows the other entity, and it gets all of its assets and liabilities. And the difference, and we'll talk about dissolution in more detail in a little bit, is that dissolution is the entity is ceasing to exist, and it's going away, and it's giving its assets, it's disposing of its liabilities, one, and then it's giving its assets to an organization or a number of organizations subject to tax law restrictions and its own governance document restrictions. So the main difference is that the liabilities are easier to dispose of in a dissolution as opposed to a merger. So we've seen an uptick in mergers or contemplated mergers, at least overall, in the last, really before COVID. That might just be our practice, but certainly during COVID, we've seen that. And from a legal perspective, the issues that you're going to deal with in a for-profit merger are fairly similar to those in a nonprofit merger. So are there outstanding contracts that are affected by the merger, where you need permission from the vendor to transfer the contract, something like that? Are there restricted donated funds that that have in the documentation something to the effect of, if you merge, then this, you have to give the money to X or something like that. That's fairly uncommon, but it is, something that when you're doing your due diligence where there is a merger, you're going to want to know. The corporate approval process in North Carolina is fairly straightforward. So the governing body of the merging organization and the survivor would each need to meet and approve the merger. You'd likely approve a merger agreement of varying complexity based on the size and complexity of the organizations in the merger. And you would also, and you're required by statute to do this, approve a plan of merger that has certain statutorily required information such as the name of the organizations and restrictions and things like that. So it's that sort of, and in some cases, I don't know if we talked too much about members last time, but in North Carolina, as in most, if not all states, a nonprofit corporation can have members. So members are the rough equivalent of stockholders, and your articles of incorporation or your bylaws can provide that your members also need to approve the merger. But the default under North Carolina law is that unless you're giving the members that authority, they don't have it. So, excuse me, it's prudent to look through the articles and bylaws to see what they say happens before a merger is to take place, especially with regard to members. And there can be obligations for like supermajorities of members and directors for mergers. So all that stuff, I know it's sort of obvious, but it's stuff you need to think about before you go forward with the merger. So in other states, it's the Attorney General's office, which is historically the entity within state government that oversees certain big nonprofit transactions and issues. That's that. In other states where there's a merger, the Attorney General's office is statutorily much more involved. In North Carolina, if it's a merger between two charitable corporations, whether those are, one of them is under North Carolina law, or it would be considered under a charitable corporation if it was under North Carolina law. In both of those situations, the AG doesn't need to be involved in a merger. But if you're transferring to a non-exempt organization, a for-profit or something like that, the AG does need to be involved. But in general, most of the mergers that we're handling, it's two charitable organizations. And then there's also this concept of merger or just transfer of a lot of your assets. And so in North Carolina, if you're transferring all or a majority of your assets outside the regular course of business, then you need to give notice to the Attorney General of that. I'm doing that right now, and the Attorney General has a long sort of list of questions and requests and what they're trying to get to there is what they want to know is that the money that's moving or the assets that are moving are going to be used for the charitable purposes for which they were intended. That's sort of the bottom line. So what you could do is, transfer a building or cash or some other asset that's a majority of your assets, and then you would need to give notice. And when you do that, there's governance considerations and tax related questions. Is there a restriction on the money from the donor, on the asset from the donor? What process is there a process in your articles or bylaws that the board says you need to follow? Things like that. And in terms of tax related, you can't transfer an asset to a for-profit for no consideration. For example, it would have to be for a fair market value, and the AG would be interested in you doing that. That really doesn't often come up. Usually, these sort of things are transfer of a significant amount of cash or assets from one charity to another. So that is another way to think about a restructuring. And now dissolution. Dissolution in a nonprofit is similar to dissolution in a for-profit in that the organization floats into the ether. It's gone. It no longer exists as a corporate entity. So this Often it's the case that you've spent down, often the reason that we'll see a dissolution is you've spent down your assets such that you can't really continue anymore with what little you do have, or you just don't have anything. And or the purpose for which you were formed goes away, or the folks that weren't the initial board and that were really the heart of the organization go away, or they're getting older, they pass away or something like that. Those are the practical reasons that we see dissolution. So when you're considering dissolution, you need to look at what your governance documents say in terms of where the assets are to go. And in a lot of older organizations, especially, what you'll see is that they've named another organization in their articles of incorporation and says it goes to X organization. What we do when we're forming organizations almost always is to, I saw one of the, I think this is the chat going on, and we will do some questions at the end, and I'm almost done. I just saw it click. So sorry, I just want to make sure. Okay, never mind. We'll do this at the end. So you want to look at what, where the money's supposed to go. And if it's a, defunct organization or something like that, you should just change the articles or change the bylaws so that probably it either mentions another organization by name, or, and I prefer this, just gives flexibility to allow for disposition of assets within the confines of what the IRS says you can do. And that is for any 501c3, valid 501c3 purposes or public purposes. So in terms of liability protections, there are some, like you're disposing of your liabilities subject to statute of limitations. One thing that's sort of interesting that I've come across in the last year or so is, and this is not that applicable to most situations, but it's something worth considering. If you're going to form a new organization that's just going to do the exact same thing as the old organization, and you're transferring all the assets from old organization to new, under the doctrine or the theory of successor liability, the liabilities don't necessarily extinguish, and somebody can use that in court against you. And that makes sense. I mean, it shouldn't be the case that you can just change forms, dissolve, and just lose any ability for somebody that could otherwise sue you to sue you. But in general, there are fairly good liability protections on dissolution. And then there are issues of restricted funds. So if somebody's given you something subject to a particular restriction, what do? You go back to the donor and see if you can get the restriction released. You spend the money before you dissolve. Potentially you can provide, it's harder, and I've not ever done this, but I suppose theoretically you could provide the money as a restricted grant to another organization, I guess. But the point is see what restrictions there are. So on dissolution, the way that the AG gets involved is the same way that they get involved on disposition of all or substantially all of your assets. So there's not a specific requirement that on dissolution you provide notice or need to get approval from the AG. If you have given all of your assets away as grants in regular course, you had $500,000 worth of assets, and you entered into grant agreements to give $100,000 a year over 5 years, that's giving money in the ordinary course of your business. So that's not going to require AG approval. If you're giving it all away at once, that is. So that is all that we're at about the 10-minute mark, and that's what I wanted to leave for questions. And if there aren't questions, I can discuss a few other things if you'd like. So
Yes. Peter, thank you. So we have actually two questions, and our timing is perfect because we'd like to do a break at 2:55 for everybody to
okay.
prep for, so that's awesome. So the first question stems from actually what you were just talking about with the dissolution, but I think could probably go further than this. So at what point do you recommend that nonprofits let other donors or organizational donors or large donors, or I guess all donors, know when when your organization is going to do something like this? Let's say like you are going to dissolve or you're going to reappropriate funds for a different use. When are you obligated to let other people know that?
well, there's sort of a legal answer, and then there's a practical donor relations kind of answer. So the legal answer is, if you're going to divert restricted funds for a purpose other than those, which they're being used for, you need to get permission to do that. If and that sort of just stands on its own. You need to do that. If it's just sort of when you're dissolving, I don't know. I mean, you would want to give some amount of notice. Ed, maybe you can jump in from just a practical perspective.
Yeah, I mean, I think a lot of this is context, and I think this actually goes back to my session last week, in which we talked about how, in a situation, in a crisis that could potentially lead to dissolution or merger or something like that, the board needs to be in front of things, and um, the board is going to be in the best position to understand the relationships that are going to be required, and what might be, what relationships might, need to be carried over, or, sort of how to handle all of those things. So, legally speaking, Peter's right. If you're going to try to divert assets, you're going to have to get permission. All that has to be done in advance. If you're going to merge or anything like that, you're not. I mean, there's no legal obligation that you tell anybody, and in fact, you might be under an NDA, for a period of time. But thinking about um, the relations and everything else around that is going to be a conversation that the board needs to have.
Thanks. And then we have one. So yes, as everything in the law, context specific, right? It depends. And then one more question for you that we got is, when you were talking about in the beginning of today's presentation about negotiating, let's say around event planning and things like that, and understanding now that we all have a COVID world in our head that things could become impossible. Do you have any suggestions for language added to contracts if outside of COVID, let's say something with the venue that they just can't do, let's say they might go out of business, or just suggestions that you have as far as what people put into these. It's a really interesting and good thing to think about.
Yeah, that's a good question. And it's hard, again, context specific, but, with respect to a force majeure type clause, don't limit it to impossibility, add commercial impracticability. Add a lot of examples of what a act of God is. Epidemic, pandemic, curtailment of transportation, particular government regulations, particular state regulations. And then the one that I found most useful is the one that I mentioned, that is, if 30% of our people can't make it because of transportation curtailment, we get our money back. And a lot of people will tell you to go pound sand if you write that under contract, but then you move it to 60%. And other than that, yeah. And I mean, the thing is, not a lot of this, thankfully, ends up in court. But that doesn't mean that you don't want a really good, strong sort of list of things that you have in there. And I think the ones that I mentioned are a good place to start.